Alright, class, we are in Chapter 1, Part 6, and we're talking about legal reasoning. And basically what legal reasoning is taking a specific factual situation that applies, for example, to a client or to yourself if you're in a business, and applying the law to it and coming out with a conclusion, which we sometimes refer to as sort of a prediction of what the outcome's going to be, applying the law to those facts of the case. So it's the process of deciding what law applies to the dispute and then applying that law to the facts and circumstances of the case. It's a method of thinking that consists of investigating, analyzing, evaluating, and interpreting information to solve a legal issue or a case. The law has to remain flexible because of cultural, technological, economic, and social changes. And sometimes there's a delayed response to those changes, a delayed response in the law. So for example, we talk about oftentimes now the changes that have occurred as a result of the internet, of computers, of electronic technology. For example, when you make a contract through an online purchase, what's the signature to the contract? And so the law has adopted a lot of optional ways of agreeing to something, an e-signature, so to speak, as opposed to an actual signature on a piece of paper. And a lot of times there's a delayed response there in terms of the recognition of the law and through either the courts or through statutory law of what would be acceptable. And oftentimes as lawyers, we have to argue those new things to establish law, first sometimes through the courts, and then later on usually the legislative body will catch on and legislate a principle. So unprecedented problems require fluidity and pliancy. Okay, so we're going to talk about the IRAC method, and later we're going to talk about the briefing case. Both of these are common methods of helping to understand a case. So let's talk about case law for a minute. When an appellate court decides a case, they issue their decision. I believe we've talked about that before, and it's in the form of an opinion. It's a written paragraph by paragraph analysis of the facts of the law, the issues in the case, and how the court is holding. That is what is the principle of law that the court has decided will apply, and then applying it to the case. So the IRAC method, with IRAC being an acronym, is where you take that case and you look for the issue, the rule, application, and conclusion. So the issue is what's the legal issue in the case. For example, let's take a look at Brown versus Board of Education. The legal issue in that case was, and it's usually stated as a question, do separate but equal schools for blacks and whites violate the Equal Protection Clause of the 14th Amendment? That's the issue. So you want to look at the facts of the case, and you want to identify from the opinion the issue. And the facts of the case, all you want are the relevant, or what we call material facts. There will be a lot of facts in there that are not particularly relevant. Okay, so for example, in Brown versus Board of Education, the actual school that the kids went to may be totally irrelevant because it's not the particular school, it's a school or two schools, one being black and one being white. So you have to make sure you pick out the material issues. What's a material issue? It's one that helps to answer the legal issue or the legal question. If it doesn't lead to an answer to the legal question or have a relevancy to the legal issue, then it's not a material fact. And then the application. How does the rule of law apply to the particular facts and circumstances of the case? So you can look for how the court decided that issue for what the rule of law is, or the holding, as we sometimes refer to it. The holding of the case, the rule of law. So in that example I gave you, the answer to the question would be yes, and then the holding would be the separate but equal schools for blacks and whites violates the Equal Protection Clause of the 14th Amendment. And the conclusion that would be drawn in that case, applying that, is that the schools in Arkansas violated the 14th Amendment. Okay. So, keep in mind that whenever you're analyzing a case, there's not necessarily going to be a right answer. Why is that? Well, what lawyers do all the time is try and distinguish cases. Okay, so let's go back to that case I dreamed up early on in the course, the one dealing with the mules. Okay, so the first case established the principle of caveat emptor, and that is that the buyer has to be responsible for what they buy, should inspect, and should know what they're buying. But the second case was a little bit different. The second case walks into the lawyer's office, tells the facts of the case, and the lawyer first thinks, well, based on caveat emptor, you're going to lose because you bought a blind mule and should have known better. But then the client says to the lawyer, but he told me that it could see. He told me that the mule could see well and guaranteed it. Okay, that changes it. So that lawyer is going to look at and make arguments to the court that precedent doesn't apply in that case because the facts were significantly different and call for a different conclusion. And that's what lawyers do all the time. So don't assume that there's always a right answer. What there is an analysis and an argument based upon that analysis that your analysis is correct and the court should follow that. So you can't always predict the outcome of lawsuits with certainty. So where does the common law come into play? The common law comes into play in modern law when there is no statutes or constitutions to apply because it's a novel case or a case of what we call first impression, or where the language of the statute or the constitution is not clear and the court has to clarify that language. Okay? So in those situations, the judges interpret the law and apply the law, but do not necessarily make the laws. Okay, now there are a set of kind of policies that appellate courts apply in trying to determine what was meant by statutory authority. We'll get into that at a later time. But usually the courts will look at the history of the making of the law. For example, what was stated by the authors of the law on the floor of Congress or on the floor of the Georgia Assembly, and does that lead to any help in interpreting the law? Okay. They also look to restatements of law, which are basically legal scholars' attempts to take the law as it exists throughout the 50 states and make it into one comprehensive singular law, and then that helps to judges to understand what the purpose is behind those laws and to then be able to interpret the law. So restatements are secondary sources of law, and there are many restatements. Okay, so we're going to stop there and we'll pick up in the next video on the sources of legal thought.